It's no secret that our phones know almost everything about us, from how many steps you've taken in a day to your exact location at any waking moment. And while that has its upsides, from more information about our health to reminders about where I parked my car, there are some serious risks to our privacy. And when our information gets into the wrong hands, there can be security risks too. And that's something President Joe Biden is aiming to protect against with a new ban on TikTok use by government officials using agency-issued devices. The ban, which was folded into the major funding bill he signed last month, follows a wave of concerns about the app owned by the Chinese company ByteDance. And it's not just social media that poses a threat. A report revealed by the ACLU last week revealed that over 150 million money transfer records were accessible without warrant to more than 600 law enforcement agencies across the country. Joining me to discuss this and more, and a series of other emerging privacy concerns. It's an emergency to me, Kade Crockford, because I'm concerned about it. You're the Director of Technology for Liberty program at the ACLU of Massachusetts. Welcome. You know, I feel like I've lived my life not worrying about privacy stuff and just kind of taking it like this is how it is now. But lately, I have become more concerned about things. And talk to us first, explain to us first about this finding from the Massachusetts law enforcement organizations. We have a list of a whole bunch of organizations, from the Boston Police Department, Bridgewater, Massachusetts Police Department, the DEA in Boston, the DEA in New England, on and on and on here. Kade, what were they looking at? Why were they looking at it, and why didn't they need a warrant?
Sorry, I'm not familiar with what you're referring to.
The ACLU report on the drug money, the transfers.
Oh,
not the drug money,
transfers.
the money transfers. Yeah.
Right. Yeah. You know, far too often in the digital age, we've seen that law enforcement is accessing very sensitive records about many, many people without a warrant. And that's simply unacceptable. You know, if the police were to try to get access to your banking records or your checkbook that is stored in your desk at home in a drawer, they would have to get a warrant from a judge before coming into your house and searching through your personal belongings to discover who you've been writing checks to. That same rule needs to apply in the digital age. There's no good reason for police to be able to access in such a dragnet kind of a capacity without individualized suspicion that someone is violating a law, let alone a serious law, before they can access sensitive records like our payment information. And so this is a really disturbing set of findings that the National ACLU uncovered, you know, revealing that for quite some time now, police all across the country have been able to access people's very sensitive financial records without that level of individualized suspicion and without a judge's permission.
And we're seeing all across the financial sector, the Venmo transfers. I mean, I've teased young people in my life that every time they say they bought cookies, I know they may not actually be cookies that they're buying. And other people may see that that's this. I can see everything. I can see my health providers, that my contact list has merged into my Venmo, that they're going to see Disney on Ice next week. And hey, maybe I'll run into them.
Yeah.
Are we just immune to this now, or do you think that it's a moment in time where we need to really ratchet up our concern about how much of our information is out there and who is looking at it?
I think people, particularly in light of the Supreme Court decision on abortion, the Dobbs decision, are realizing over the past few months in particular that there's so much information that we leave behind us in digital formats with private companies every single day, just by virtue of doing the ordinary human business that we all have to do, going to school, you know, doing our jobs, communicating with our childcare providers and our healthcare providers, looking up information online about how to self-manage an abortion, paying for abortion pills online. These are the kinds of things I think that everyone instinctively wants to remain private, but for a couple of different reasons, our laws have not really kept pace. And a lot of times, technology companies themselves have not privileged privacy and security over, shareability. So, for example, Venmo was criticized by privacy activists a number of years ago for not by default making people's transactions private. So, if you want to, you can go in on the Venmo app and make all of your transactions private so that random people on the internet or police officers or anyone else can't look up your account and see, who you've been exchanging money with and what the little notes say about what that money exchange is about. But still, a lot of people do not have that setting turned on. So, part of this is on technology companies to build in privacy and security by design, by default. But some of it's also on our lawmakers, right? We really need to step up to the plate in Massachusetts, in other state legislatures at the federal level, to impose some basic privacy and security safeguards so that not everybody has to be a privacy expert, right? It's too much to ask of ordinary people, especially young people who are just starting to get a handle on how to even have a bank account, right? To manage those kinds of things. There should be some protections in place across the board so that not everybody has to have an advanced degree in privacy or security to be safe online.
Well, they also have both an expectation that it's not private and doesn't need to be private, and that it is going to be private, which is a funny space where they live in. I had this kind of realization when Elon Musk bought Twitter that I have no idea my Twitter DMs are those mine? Are they his? Like I don't know. I try to follow the rule that I don't put anything in writing that I don't want to see on the front page of the Boston Herald. So I think I'm okay.
That's right.
Listen, I want to talk quickly, too, about this case in New York at Madison Square Garden. Of course, the ACLU and the ACLU Massachusetts working hard about facial recognition software, both how police use it. But this is a private company, the Madison Square Garden, who used facial recognition to identify a patron who was going to a holiday show with her kid, if I remember the story correctly. It turns out she was an employee at a law office. Her law office had a case where someone was suing Madison Square Garden. She was not involved in the case, but the facial recognition registered her face. She was asked for an ID and she was denied entry into Madison Square Garden because she was on a list that they didn't want her there. There's no real law that I understand that prevents them from doing this. There may be some obscure, I don't know, public circus law or something that they have in New York that allows everyone to go to a public event. This is an example, though, of how lawmakers are unable to really keep up with the technology.
That's right. Yeah, this is a fascinating case, and it's really disturbing. What this case shows is that facial recognition technology can be used not only by police to investigate crimes, which is something that we're working on here in Massachusetts. We're very much hopeful that the legislature will finish the job this session, early in the session, we hope, by implementing recommendations that came from a special legislative commission to increase the privacy protections and due process protections around police use of the technology. But yeah, the Madison Square Garden case raises a whole other set of issues, which is what happens when corporations are using this technology effectively to police who can enter their space, right? So in this case, I think it's pretty egregious that simply working for a law firm who's engaged in litigation against one of the many companies that's owned by the umbrella corporation that owns the Madison Square Garden venue, means that you can't go to a restaurant that's owned by these people. You can't take your kids, as in this case, to see the Rockettes with her Girl Scout troop. There are other folks who have been excluded from seeing athletic performances, sports games at Madison Square Garden because of this. What we need in Massachusetts, what they need in New York to prohibit this, is a law like what the state of Illinois has. So Illinois has the most advanced law in the country that protects our rights essentially to privacy over our own biometric data. So biometric just means anything that's unique to each of us. So our face print is a biometric data piece. And what the Biometric Information Privacy Act does in Illinois, and what we're hoping to accomplish here in Massachusetts, is it essentially says companies like Madison Square Garden or like Walmart or Walgreens cannot collect your biometric data without your consent. So this could not have happened in Illinois because in Illinois, a venue would be required to get the consent of the people on that list before, turning their image into a biometric data point that could then be uploaded into a system like this. So that's really important because I don't think anybody wants to live in a world where in the future you can sort of capriciously be denied entry into, a restaurant or a public venue like, TD Garden or something like that because, your name is on a list or, even more frighteningly maybe because you look like someone whose name is on a list because we know that these technologies don't always work.
So, just as we wrap up here, Kate, are you optimistic or worried about 2023 when it comes to privacy issues around technology? Are we starting to wake up a bit and take action, or should we wake up and take action?
I'm really optimistic, actually. In recent years, Massachusetts lawmakers have made significant progress on some of these issues. Like I said, we had the Special Legislative Commission that wrapped up its business last year on police use of facial recognition technology. The recommendations that that group came out with were endorsed by groups as varied and diverse as the Attorney General, former Attorney General Maura Healey's office, the state police, the NAACP, the ACLU, the Public Defender's Office, and I could go on and on. So we think that there are some really common sense, kind of easy political wins that we need to put in place this session. There's also the whole other kind of Pandora's box of consumer privacy issues. And this session, we're very proud to have worked with lawmakers in the House and the Senate and a number of coalition partners to support legislation that would create omnibus privacy protections for all kinds of online behaviors that we engage in. And maybe most excitingly, and if you want to have me back on the show to talk more about this, I'd be happy to join, to prohibit companies from selling and trading our cell phone location information, which unfortunately is happening all across the country right now and is a totally unregulated Wild West that exposes all of us to very, very serious privacy and even personal safety harms every day. So I'm really confident that lawmakers are taking this stuff really seriously and that we're going to get some pretty significant work done this session.
Well, we'll put you on the books for the next time up. I appreciate your time and your expertise on this. Kade Crockford from the Massachusetts ACLU. Thank you so much.
Thank you.